This is Team 12's PowerPoint and video presentation on the Americans with Disabilities Act. So what is the Americans with Disabilities Act? We're going to start off by showing a little skit about a disabled person and some of their exploits. We assume this is a park ranger at the Grand Canyon. So to begin with, in July 26, 1990, the ADA was signed into law by George Bush Sr. And then in July of 1992, the law went into effect. More recently, September 25th of 2008, the ADA Amendment Act was signed into law, and that was done by George W. Bush. And most recently, July 26th of this year, 2010, the ADA celebrated its 20th anniversary. At the celebration, there was 193 wheelchair formation, which was the largest moving formation of wheelchairs ever assembled. So, what is the Act? Well, Title I of the Americans with Disabilities Act prohibits its employers from discriminating against a qualified individual because of a disability, and this is in regard to job application procedures, hiring, advancement, discharge, compensation, job training, other terms, conditions, and privileges of employment. So basically, if it relates to employment, it's covered. So, impermissible discrimination. So employers are prohibited from intentionally discriminating against disabled persons and engaging in employment practices that are not intentionally discriminatory, but have the effect of discriminating against disabled persons or perpetuating past effects of such discrimination. Okay, so who's covered? An individual is considered to have a disability if he or she has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded to have such an impairment. So not only do you have to have it, you could just have the perception of having it. So, controversy. Some of the controversial inclusions are HIV, and while it's not specifically covered under the ADA, the Supreme Court has held that HIV-positive individuals are disabled within the meaning of the ADA. Additionally, genetics. The Genetic Information Non-Discrimination Act of 2008, GINA, prohibits the discrimination based on genetic information. Okay. So now we know who's covered, what's not covered. Homosexuality, bisexuality, sexual behavior disorders, compulsive gambling, kleptomania, pyromania, and psychoactive substance abuse disorders are not covered. Sorry for all you firebugs. All right, so what are some fun facts about the ADA? Well, an individual with a minor non-chronic condition of short duration, such as a sprained broken limb or the flu, generally would not be covered, even if it's swine flu. So basically, if it's short-term in nature or very short-term in nature, it's not covered under disabilities. So more fun facts. People who are addicted to illegal drugs are not covered under the ADA. However, if you're addicted to alcohol, you're okay. So what do the employers do for those people who are disabled? It's reasonable accommodation. The ADA requires that employers make reasonable accommodations to an employee's disability. There are actually only 3 defenses to employer setting up an ADA. Undue hardship is the first of those. And basically, this is an activity requiring significant difficulty or expense when considered in light of the nature and cost of the accommodation needed, the impact of the accommodation on the facility, the overall financial resources of the employer, and the type of operation of the employer. So it can't create a hardship that's too difficult for the employer to overcome. Secondly, you've got business necessity. And what this is an employee tests, qualifications, standards, and other selection criteria are acceptable in the ADA if they relate to the job and consistent with business necessity. And this basically means if you have to be able to do something to do the job and you can't because of your disability, that's covered. And then finally, you have permissible exclusion. An applicant or employee who is disabled may be excluded from the employment opportunity only if, by reason of the disability, he or she cannot perform the essential functions of the job of the individual's employment poses significant risk to the health or safety of others. Okay, so what federal agencies have ADA responsibilities? Well, you've got the EEOC, Department of Transportation, you've got the FCC, you got the Proposed Design Guidelines Access Board, Department of Education, Department of Healthcare, Department of Labor, Housing, Parks and Recreation, USDA Agriculture. Wow. Some ADA statistics for you. 54 million people have a disability. 5% of kids from 5 to 17 have disability. 10% of people from 18 to 64 have disabilities. 38% of adults over 65 have disabilities. Takeaway, the older you get, the more likely you are to have a disability. 11 million people is the number of people 6 and older who need personal assistance every single day. 3.3 million people 15 and older use a wheelchair. 10 million people use a walking aid such as a cane, crutches, or a walker. 13.3 million is the number of 16 to 64-year-olds reported difficulty finding a job or remaining employed because of a health condition. 46% of people 21 to 64 have some type of disability who were employed. That's versus 84% who do not have a disability. 48% of people 21 to 64 with a non-severe disability who work full-time versus 63% of those without disabilities. Finally, a positive note, 98% of transit buses were lift or ramp equipped as of 2007, so practically all of them. A new fun fact, and it's a recurring theme in a lot of places, is actually peanut-free zones. A peanut allergy is considered a disability by the ADA now, and there's even schools and baseball stadiums where peanuts are banned. Some of the ADA design standards, you've got basic requirements, and that's at least one wheelchair accessible entrance providing access to all parts of the building. You've got signs with high contrast letters and braille for those who are visually impaired, and parking access with ample room for entering, exiting the vehicle, and close to the building entrance. So it's got to be close and it's got to be big to allow for the lowering of a wheelchair. Some specific requirements, you've got a maximum length for items protruding from a wall, such as 4 inches. If it's above 27 inches, actually below 27 inches, there is no requirement. You've got minimum headroom and walkways of 80 inches. Those are who are disablingly tall. Elevators can only come within a half inch of a floor landing. Restaurant tables and countertops have to be between 28 and 34 inches. And wheelchair accessible ramps have to have a maximum slope of 1 to 12. Some of the legal cases. The first is United States versus Quick Trip Corporation. In 2010, the United States Department of Justice successfully sued the gas station chain for, among several violations, failing to meet ADA access requirements at its stores. You've got Sutton versus the United States. In 1999, the Sutton twins sued the United Airlines, claiming that their visual impairments were used by United to discriminate against them. The U.S. Supreme Court ruled in favor of United because the Sutton twins were not considered disabled. Since their visual impairments were correctable with contact lenses, For a short time, corrective disorders were not considered disabilities with respect to the ADA rules. This precedent was actually overturned in 2008. Next is Toyota Motor Manufacturing versus Williams. The Toyota versus Williams case is another example of the courts and legislation fumbling on interpretation of the ADA rules. The case involved Williams claiming she was fired because her carpal tunnel syndrome. Her first appeal overturned the original ruling, claiming that carpal tunnel is covered. Then the U.S. Supreme Court overturned that decision with the opinion that non-permanent impairments were not covered by the ADA. This ruling was again overturned by the ADA Amendment Act of 2008, as Congress believed the term substantially limited was defined too narrowly. And finally, we've got Kindle use at universities investigated. No civil suits have been brought. There is much discussion regarding several universities considering supplying electronic reading devices to students to make academic content more available to persons with certain disabilities. Maybe the UFMBA program will add Kindles to our arsenal of electronics to avoid possible civil suits. Maybe not. All right, back to September 25th, 2008, and the Amendments Act of the ADA. So it overturns the ruling of Sutton versus the United States and Toyota versus Williams. These cases were established as too narrow definitions of disability and overly demanding of terms of substantial limitations. It intends to create a greater focus on whether entities covered under the ADA have complied with their obligations and to convey the question of whether an individual's impairment is a disability under the ADA and should not demand extensive analysis. Thank you for your time, and this is the end.